Hi guys, this is Asal. I'm studying for the bar and I would like to review my notes with you. So today I'm studying professional responsibility and I'll be talking about the thing that clients complain about the most. So think to yourself, what is the thing that clients complain about the most? Clients constantly will complain about the lawyer charging way too high. Apparently, lawyers have a reputation for charging way too high, and that's what the clients think. So, in this video, I'll be going about what are reasonable fees, when is a writing required, and contingent fees. I'll be defining contingent fees for you, and finally, I'll be talking about fee divisions between lawyers. So, let's jump right into it. The first thing I would like to talk about is Model Rules of Professional Conduct 1.5a, which states that a lawyer shall not make an agreement for, charge, or collect an unreasonable fee or an unreasonable amount of expenses. So this rule is actually right here. I would like to bring it in front of the camera so that I can show it to you right here. This rule has actually 8 factors. So this is factor number 1, number 2, and it goes away all the way till the next page. The 8th factor is right here. Okay, so the first factor is the time, label, novelty, and the skill required. The second factor is likelihood that other clients won't come. For example, what does that mean? For example, if a lawyer is going to be defending a child molester or someone who has a really bad type of character, that if the lawyer defends that person, then he might lose a lot of clients in the future, then he could charge a little bit more. Or for example, the first factor with the time, label, novelty, and skill, let's say that this job is going to need extra skill and extra time, and the lawyer is going to be under a lot of time pressure to perform and perform fast. So when that happens, the lawyer can charge extra. When there's a likelihood that other clients won't come, this is the second factor, he can charge extra. Or there's also the third factor is the customary fee in the area. For example, the customary fee in the area might be a little bit more, a little higher, and the amount involved and the results. And the fifth factor is the time pressure. So how much time pressure is the lawyer under? For example, if the client comes to him and there's the statute of limitations and it's running out and the lawyer has to act fast, then he is under time pressure. He's going to have to put all his other life duties on hold to do that. So that's very important. When that happens, he can charge a little more. The next thing is the nature and length of the relationship. So what is the nature and length of the relationship? Depending on that, the lawyer might be able to charge more. And also the lawyer's reputation and experience. And finally, the contingent fee or the fixed fees. So when is a written agreement required? The fixed fee agreement is preferably in writing and not required necessarily, but it's preferably in writing, but it's not necessarily required to be in writing. And with the contingent fee arrangement, must reduce to writing and must state how the fee is calculated. Okay, so that's very important. Remember, with the contingent fee agreement, it must be reduced to writing and must state how the fee is calculated. The next thing I'll be talking about is when are contingent fees prohibited. There's certain cases that the contingent fee is prohibited. So what are those? Is certain domestic relation cases, or if the defendant is in a criminal case. Next thing I'll be talking about is fee sharing between lawyers. So how does that work? Usually there's no rules for lawyers in the same firm. Basically, lawyers in the same firm, they share the fees and no specific rules for that. But there's some limitations on lawyers from different firms. So remember, there's the difference there. Okay, so in this video, what I talked about is the reasonableness. So it must be reasonable fee. And the next thing, I listed the 8 factors right here from page 17 of this book. So that's where you find them. I listed the 8 factors, and the next thing I talked about is the contingent agreement that must be in writing, And finally, I talked about the fee sharing, of how it works between different firms and people of the same firm. So that's pretty much everything I wanted to talk about today. I really hope you enjoy studying. Good luck!